Good morning. If you could please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Good morning, everyone. I want to welcome you to the September 14th, 2020 Land Use Hearing Officer hearing. My name is Susan Finch, and I'll be presiding as the hearing officer over today's cases. Let me start by introducing Mr. Tom Hisney of the Development Services Department, who will go over our agenda this afternoon. Mr. Hisney.
Good morning, Mrs. Finch. I'd like to introduce to my left is Carmen Mason of Development Services. Also, we're going to be joined virtually today by Cameron Clark of the County Attorney's Office. We have no changes to the agenda, but we do have some published withdrawals and continuances. All right. Item A1, special use 19-1174. Applicant is Dennis Donaldson. This case has been scheduled for the September 29th, 2020 Land Use Hearing Officer meeting. Item A2, variance application 20-0244. The applicant is Russell Capel. This case has been scheduled for the September 29th, 2020 Land Use Hearing Officer meeting. Item A3, variance application 20-0317. The applicant is John Schuman. This case has been scheduled for the September 29th, 2020 Land Use Hearing Officer meeting. Item A4, variance application 20-0372. Applicants Martinez Yene and Mujica Maria. This case has been scheduled for the September 29th, 2020 Land Use Hearing Officer meeting. Item A5, variance application 20-0398. The applicant is Eloy Martinez. This case has been scheduled for the September 29th, 2020 Land Use Hearing Officer meeting. Item A6, variance application 20-0496. The applicant is Abby Feely. This application is being continued by staff to the October 19th, 2020 Land Use Hearing Officer meeting. And finally, item A7, special use 20-1017. The applicant is TSP's Companies Incorporated. This application is being continued by the applicant to the December 14th, 2020 Land Use Hearing Officer meeting.
Thank you, Mr. Hussein. I appreciate it. Let me start by going over our procedures and our hearing process for today. I'll conduct the variance and the special use hearings and render a decision within 15 business days following today's hearing. Our hearing today is informal. I'll ask questions related to direct testimony presented today. I'll call in question witnesses as I deem appropriate, and we'll decide all matters on procedure. Irrelevant, immaterial, or unduly repetitious evidence will be excluded. Any part of evidence may be received in written form, and all testimony must be under oath. Hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but shall not be sufficient in and of itself to support a finding by me unless it would be admissible over objections in a civil action. Our order of presentation is as follows. For variances, the Development Services Department goes first. They present their introduction as well as the county staff report. Then we'll go to the applicant. The applicant has 15 minutes to make their presentation. We'll then turn to proponents, anyone who wants to speak in favor of an application. They have 15 minutes for the entire group. And likewise, when we go to opponents, anyone who would like to oppose an application, they also have 15 minutes total. We'll go back to county staff, who has 5 minutes to address any issues that we've heard today. And then finally, we go back to the applicant, who has 5 minutes for rebuttal. We have 2 special use applications on our agenda today. In that case, the order is just a little bit different. The applicant goes first on those special uses, and then the Development Services Department staff person assigned to the case will present their staff findings. Otherwise, the order is the same, with the addition of the Planning Commission, who will participate for those special use applications regarding the land excavation site. I don't think we'll have this issue, but the 15 minutes for proponents and opponents, that is a total time. So if there are a lot of people that want to speak, we'll ask you to raise your hand, and we will divide that 15 minutes between. The clerk's office will count that, and then we will go accordingly. If you do want to speak, you come up to the podium, or if you are testifying virtually, if you can always start by giving us your name and address for the record. We are recording this and we want to make sure we have it correct. And then if you are in person, after you're done speaking, if you could see Will over here to my right, he's from the clerk's office, and if you could sign in also with your name and address and the application number that you were speaking to. Let me turn to the county attorney, who will explain your rights to appeal decisions made by the land use hearing officer. Mr. Clark.
Thank you, Ms. Finch. My name is Cameron Clark. I'm an assistant county attorney. This land use hearing officer public hearing is for variance and special use requests. This is a time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record that is made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, by county staff, and by any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. First is the applicant. Second is anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the Appeals Board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the Appeals Board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the Appeals Board that is outside the record created at today's hearing could jeopardize the legality of the Appeals Board decision, and the presenter of that evidence could hurt their own cause. The safest course of action then is to write in any comment that you make today and to repeat those comments to the Appeals Board. Thank you.
Mr. Clark, I appreciate it. As I mentioned, all testimony must be under oath. So if you do plan to speak today, if you could please stand, raise your right hand, and also virtually, if you plan to speak, if you could raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you so much. Have a seat. Mr. Hisney, if you could please call the first case.
We have no vested rights cases, no fee waiver requests, no reconsideration requests, no site development variance requests, no sign variance requests, which takes us then to section G of the agenda, general variances. First case is item G1, variance 19-1470. The applicant is RU Project Management Group, LLC. The request is for a variance to lot development standards. Staff findings will be presented by Tanya Chapella.
Chapella?
Yeah, can you hear me?
Yes, we can. Go ahead.
Okay, the applicant is requesting a setback variance to accommodate an existing carport on property zone PV 77-0174. For the certified general site plan for PV, minimum required setbacks are as follows: front 20 feet, side 5 feet, and rear 10 feet. The applicant requests a 2-foot reduction to the required setback to allow a front setback of 18 feet. I'm glad to answer your question.
I don't have any this time, but thank you. Is the applicant here? Good morning.
Good morning. Ruth Londono, 1502 West Bush Boulevard, Tampa, Florida. I'm here for the variance 191470 to request reduce the front setback. I have a question. Do you have for the screen to show the
Yes,
pictures?
right there.
Okay. This is in here the site plan. Okay. We are requesting today is to reduce the front setback. Okay, we are in here to request to reduce the front setback. The required is 20 feet, and we are asking to reduce 2 feet to get 18 setback up front. That's the only request that we have today. We have this one, a carport on the front. And that is after the variance be approved, the owner go to request a building permit after the fact building permit. I have some pictures also from the property. Like that. Okay, that's the carport here. Okay,
So the carport was there when they bought the house?
no, they built the carport. What happened was that they was thinking that only request to the homeowner association, and they. Okay, let me bring. Okay, I have the homeowner association here. Okay, they was thinking only that with the approval from the homeowner association was okay. And the board for the homeowner association, they approved on 2018.
So they thought they only had to go to the homeowners association to
Yeah,
get the
and they
approval?
was thinking that was all the requirements, and they don't know that they need to apply for building permit.
And how did code enforcement?
They
get
have a
notice of it?
code enforcement case.
Right. Do they know how that came to be? Were they looking to pull a permit for something else, or perhaps someone reported it? Is that what happened?
No, that somebody called to code enforcement and they report, and they get the code enforcement.
I see. Okay.
We need to request after the variance be approved to reduce the front setback. We need to request for the ATF after the fact permit.
Right.
If you see this one, this is a cul-de-sac, this is a core lot. If you see in here, they have 24 feet, but they continue with this line. But because this here have more front, that was the reason. If you see here, that's 24, and here is 19, and in here go to be 18.
I see.
Okay, if you have any question?
I don't. You answered my questions. Thank you very
Okay.
much.
I have some affidavits for the neighborhood
Okay.
that if you want, I can provide this one. They support the,
Yeah. If you want to submit them into the record, you can hand them to
Okay.
Will and I'll take a look at them.
okay, thank you so much.
Thank you for your testimony. I appreciate it. Is there anyone that would like to speak in support? Anyone in favor of this application? Seeing no one, anyone in opposition? No one. All right. Mr. Hisney, anything else?
No, ma'am.
Okay, then with that, we'll close variance 19-1470 and go to the next case.
All right, next case is item G2, variance application 20-0494. The applicant is Corwin and Nikki Wills. The requests are variance to lot development standards, to accessory structure requirements, and also to fence regulations. Staff findings will be presented by Tanya Chapella.
You're still muted, Tanya. Ms. Chapella, you're muted.
You're muted.
The applicant requests a 20-foot reduction to the required setback to allow a front setback of 30 feet from the south property line along Sweet Magnolia Lane.
Ms.
For the
Chapella, you
first
may need to
proposed
repeat that.
garage, we have the Land Development Code, Section 61104C1, accessory structures shall be permitted in front yards.
Excuse me, Ms. Chapella.
Required front yard, or 50 feet, whichever is less. For the Land Development Code, Section 60101, the required minimum front yard setback for property zone ASC1 is 50 feet. Also, Land Development Code, Section 61104B, accessory structures greater than 15 feet in height must be principal building setbacks. So per the site plan submitted by the applicant, the proposed garage will have a height of 20 feet, 6 inches. So the applicant requests a 20-foot reduction to the required setback to allow a front setback of 30 feet from the south property line along Sweet Magnolias Lane. The third variance is for a fence. So the required setback is 50 feet, but the applicant requests a 2-foot increase in the permitted fence height to allow a 6-foot high fence within the required front yards on the south and east side of the lot. As shown on the site plan, the fence will have 0 setback from the south property line and 15-foot setback from the east and west property lines. As a findings, I have that the lot is platted. There is a platted conservation area and 30-foot conservation area setback along the subject parcel's north property line. The conservation area and setback line are shown on the site plan submitted by the applicant. However, the site plan is not a certified survey. Therefore, if it is determined at the time of building plan review that proposed improvement encroach into the conservation area setback, the applicant will be required to revise the plans or seek other remedies. I'm glad to answer your questions if you have any.
Mr. Pella, I don't think you were aware, but the beginning part of your presentation, you were muted. So Mr. Hisney is just going to go briefly over the first part, just to make sure we have it all on the record.
Yes, the applicant is requesting variances to accommodate a proposed home, a detached garage, and a fence on a corner lot zoned ASC1. The variance that was missed because Tanya's mic was muted is the setback variance for the proposed home. Per LDC section 60101, a minimum front yard setback of 50 feet is required for this property. The applicant requests a 20-foot reduction to the required setback to allow a front setback of 30 feet from the south property line along Sweet Magnolias Lane. The other variants that were requested were described by Ms. Chapello.
All right, fair enough. Thank you so much. Is the applicant here? Good morning.
Wonder if I could just get this to the clerk. Good morning, hearing officer, staff, Todd Pressman, 202nd Avenue South, number 451 in St. Petersburg, Florida. Good morning, hearing officer, staff, Todd Pressman, 202nd Avenue South, number 451 in St. Petersburg, Florida. I have a PowerPoint for you. If we can go to that, please. Great, thank you. So, hearing officer, this is variance 20-0494. I'm here today with, want to stand up, Mr. and Mrs. Corn Wills, who are here today. It's very important to them they came down here today because they wanted to make sure you know that they are very concerned and they are here and this is important for them. This is located out in the east part of the county, specifically on Sweet Magnolias Lane at McIntosh, north of Jess Walden Road. This is for a single-family home in AS1C zoning, single-family lot, conventional 1-acre lots. Variances, as the staff has indicated, I won't repeat them word for word, but setback for the primary home, setback for the garage, and for the fence. Well, the fence actually is in regard to a height variance. This is the elevations as sent to me by their architect for the home structure. And this is a site plan just to show you, I'll go into more detail, but generally where the home is located and where the garage is located and the fence line on the property line. This is the fence as proposed. It'll be an open style fence. I've had a lot of discussions with the neighbors. This was an option that the Wills went to, so it remained very open looking and not enclosed. So on Sweet Magnolias Lane, this is the site as indicated. And I'd like you to notice right off the front, hearing officer, that this lot is shaped dramatically different than any other lot in this particular subdivision and further out, which I'll show you. It's long and thin. In fact, it's extremely long and extremely thin compared to virtually every other lot in the immediate subdivision. When you pull out from that, there's not a single lot in the immediate area or vicinity that is shaped like it. The only one that would be even reasonably or minimally close would be the one immediately to the north, but you can see that is probably by eye double the width, except at the end. All the other lots are very large, rectangular in shape. This is an unusual, unique, singular lot. Now, this lot is further compounded with a tremendous hardship, and that is a conservation area and creek that runs through the rear of the lot. This is the line by the property appraiser's environmental line, just to keep it very simple and clear. As you can see, a great deal of this lot is eaten up. And per the architect, he was indicating that almost 2/3 of the lot is eaten up by setback and by the encroachment or the impact of this environmental area. This is the U.S. National Wetlands Survey, shows you where that line runs. And this is the applicant survey that shows it as well with the 30-foot setback. So you can see it has a dramatic bite out of the property compounded by the 50-foot setback. Of course, that's compounded because this is a very thin lot. It's unique, it's singular. All those factors come together to really decimate this lot in terms of what could be buildable compared to any others. So this is on their site plan, yellow line showing the conservation line and then the EPC wetback line. Now you also notice the location of the home is further back from the side setback or further back from the side so it doesn't encroach upon the neighbor there. And of course the garage is in the center. So this is on the site. If you're looking to the rear, this is the creek and conservation area. It's a very nice view. This is another shot of it. So you can see it's a pretty substantial and you have a slope coming down as well. Mr. Wills wanted me to make sure that you knew that there were some trees that were taken down. He had hired a contractor to do so. I went a little bit further than it should have. And he has completed the work for that. And per an email from Krista Hull, the property is now in compliance. So there was an issue there. It was a hired out element and as I understand it. And again, the property is now in compliance in that regard. So Mr. Wills wants to be a good neighbor and address what needs to be done. So looking specifically at the criteria, hearing officer, explaining how the alleged hardships and practical difficulties are unique and singular. I think I reviewed that, but specifically, as I indicate here, the architect indicates that all of these factors coming together eliminates 2/3 of the lot. It leaves a 23-foot strip buildable, compounded by all those elements. That also impacts the ability to place a fence, which everyone has for security purposes, be able to put it in a reasonable place and a reasonable distance. And of course, these variances also protect the sensitive environmental area along the rear. Describe how little requirements of the Land Development Code would deprive the rights of commonly enjoyed by others. Well, the other lots are very large. They have different proportions, different shapes. Most of them have no natural wetlands to contend with, or excuse me, the same conservation and wetland area. Some do, some don't. In the entire area, most of them do not. Because of these three hardship elements, this lot and proposed structures are deprived a tremendous buildable lot area, unlike all the other properties. So it would deprive the Wills of being able to have the same type of buildable rights for a fence, for the 2 feet on the fence, and also for the setback to the structures. I should also mention, as I may, that in discussions with the neighbors, the Wills originally came in with only a 20-foot front setback. After speaking with the neighbors, we worked to sharpen the plan, and that's why we're here today, the 30-foot setback. So the Wills have done as much as they can, in our opinion, to provide as minimum setback or minimum variances as possible. Item number 3 is to explain how the variance of allow will not substantially interfere with the rights of others whose property will be affected. The variance will bring the site into better alignment or par with the other properties in the vicinity. The base of the variance are reflective of the unique circumstances, bring the site into better similar conformance and practical elements on the property. The home and structure are more centered on the lot, so they're not pressing to the sides. That we do not see or understand in any way that could be injurious or would interfere with any property owner and would allow a more practical and orderly fashion placement. The proposed fence is also open style, so it is not a closed off element on the property line. Again, that variance is just for 2 feet height, 2 feet height to be higher at the front 50 feet. 4, explain how the variance is in harmony with and serves the general intent and purpose of the LDC and the comprehensive plan. These variances, as we see them, would be consistent, fair, and efficient, addressing the natural resources and regarding the excessive setback and how it affects this lot. Done that in light of several of the unique hardships. It will provide a home that allows them the same abilities and enjoyment that all the others have. This is a residential ASC 1 single-family home, which is allowed at this location. Criteria number 5, explain how the situation sought to be relieved by the variance does not result by legal act. I think it's very clear. None of the hardships that are created by the wills. It's created by topographical and geographical conditions and shape of the lot and the governmental setback. And 6, explain how allowing the variance will result in substantial justice being done concerning both the public benefits intended. The variance will allow the will have lot structures and fence placement in the same general configuration or rights as other properties in the area of which addresses each of the variance requested. Failure to do so will result in a lot that is severely damaged and impaired. It will allow the harmonious and orderly development of the neighborhood in an equally distributed fashion as they relate to each other. So in summary, I think I've beat the horse here pretty hard. We do feel this is a 100% justified variance. We have worked hard to make it sure it's the minimum variance, and we ask for your consideration and support. Thank you.
Thank you for your testimony. I appreciate it. All right, we'll turn to anyone that would like to speak in favor. Anyone in support? All right, seeing no one, and anyone in, would you like to come? Yes, absolutely, come forward. The podium hides my view over there. If you could give us your name and address, please.
Hi, my name is Nikki Wills. I currently reside at 1410 Emerald Hill Way, Valrico, Florida, 33594. I'm here with my husband, Corin Wills. Thank you, hearing officer and staff, for hearing us out today. And thanks to Mr. Pressman as well. We're simply here to get the variance approved because we want to be in our forever home. I met most of the neighbors, and I appreciate the fact that they're here and want to hear us out today, but we just want to be in our forever home and just get everybody's support, and with as many inconveniences as possible. And I really need your help to allow us to be able to do this. Thank you.
Thank you so much. If you could please sign in with the clerk's office. Anyone else that would like to speak in support? All right, seeing no one, I have one person signed up to speak in opposition virtually. Is there anyone in the room that wants to speak in opposition? All right, if you could come forward. So I have 2 people in the room and 1 person virtually. Good morning.
Good morning. My name is Richard Bennett. My mailing address is 608 North Parsons Avenue in Brandon, 33510. But I am the owner of the home on lot 4 in the subdivision, okay? And Ms. Finch, I have a cover letter and some documents. Do you want to see this, or do you want me to just hand them to the clerk?
Is it a petition?
No, it is not a petition. I'll hand these to him. There are some documents that I'm submitting into the public record. There are copies of some emails and so on that have gone on, copies of the deed restrictions. But do you want to see my outline, or do you want to just listen?
I'll listen, and if you submit it into the record, I'll read it later. Absolutely.
All right, as I said, I've submitted documents to the record that I'm hoping that you will review as part of your thinking about this. And I do disagree with several of the things that Mr. Pressman said. There are EPC wetland setbacks for other lots in the subdivision. There are other irregular shaped lots within the subdivision. First, I had a career of 30 years in the real estate business. I mostly sold vacant lots. And I think when you buy a vacant lot, it makes sense to either purchase a lot that works for the home that you've designed, or if you find a lot that you fall in love with, then design a home that fits the lot. And in this case, neither of those happened. It just doesn't make any sense. I've submitted a copy of the deed restrictions And a comment made by my attorney that although the county does not enforce deed restrictions, and I understand that, if the county knowingly knows that there are deed restrictions and then amends them or changes them to the detriment of the neighbors, it possibly drags the county in to any appeal or court proceedings, because then it's the county's fault that the deed restrictions were changed. I think it's something for the county attorney to think about real hard. We have had issues with this case since the beginning because there has been multiple, and I mean many, changes, revisions, errors, omissions. It has been very hard to follow. It's been the worst that I've ever seen. There have been communication problems with staff and the representative. Lack of communication, no communication, incorrect communication. It has been something that I think the county can do a better job. They have changed the accessory structure, and somehow they're only calculating the first floor. But they have now put it on the record that they want a higher height, which makes it a two-story building. And you cannot only count the footprint. You don't count square footage of a 2 or 3 story house or a 2 or 3 story commercial building just based on the footprint. All of the square foot counts. And they have now put it on the record that this is a 2-story building and that they're going to have another use, not a garage, a gym on the second floor. So now their drawing shows 1,200 is really 2,400 square feet. It's an incorrect request for a variance, and we are totally opposed to a 2,400 square foot building. I have on at least 3 occasions, and Ms. Finch, I'm telling you, this seems very good to me. It does, the whole situation here. But I have requested of the county on at least 3 occasions why the meeting was here and what has happened at the county center auditorium where these kind of hearings are normally held. I've taken it all the way because everyone's concerned about the safety and health and welfare of all the people. It's gone all the way to the county administrator's office, and nobody has answered the question, what is going on at the county center? And I would like an answer to that. The details on the appeals process, it was very hard to make out what the county attorney was saying. I'd like to know how many days after your decision, if there's an appeal to be filed and how you do that, or if there's something in writing that can be given. The tree resolution issue where trees were illegally cut without permits, some large oak trees, and that this is now in compliance. Have the trees been planted? I don't understand this because I'm not aware of trees being replaced. I saw a picture of someone standing next to a bunch of small trees, but there was supposed to either be a fine or replacement of trees, and it said on the screen that it was in compliance, but I'm not aware of any trees being replaced. So I don't know how it could be in compliance, and I don't think any variance on any of these issues should be approved until that's totally 100% in compliance. Also, when the last hearing back in July was canceled, I put an email out to the county staff and to Mr. Pressman offering to meet and discuss and try and resolve this. I got 0 response from anybody, period, no response. And I want to make it clear that the deed restrictions, and Ms. Finch, this is the most important thing. The deed restrictions tie the setbacks to the plat. The deed restrictions cover accessory structures. The deed restrictions cover fencing. They cover all of the things. So it's not just county regulations they're trying to break. They're also trying to break a whole bunch of the deed restrictions. And that's an issue that the county simply must take into consideration because the other neighbors have met the deed restrictions. And it's a civil matter for that. And I guess to conclude, I have to be in opposition of this because a 2-story, 2,400 square foot accessory building doesn't work. We have no guarantee of the type of fencing that they would put up. Only that it would be 6 feet high if you grant the variance. And if you look at the drawing closely of the site plan that I have submitted in the documents and what Mr. Pressman showed, the house that they designed will fit on the lot without any variance. They just have to move it further to the west. I don't understand why they need this variance at all. And thank you very much for your time.
Thank you for your testimony. If you could please sign in. Yes, sir. Next, please. Good morning.
Morning. Michael George. Address is 12804 Sweet Magnolias Lane in Dover. It's lot number 4. Actually, Mr. Bennett, I believe, has lot number 5.
Mr. George, you signed up. I have you signed up virtually, so it's one and the same person.
No,
Yeah.
I
Okay.
didn't sign up virtually. That was for a hearing a long time ago.
All right. Okay, my apologies. Go ahead.
I'm here. All right, I'm going to present to the clerk a copy of my document along with 5 exhibits.
I do need to correct the record. Mike spoke correctly. My lot is 5, not 4.
Thank you, sir.
Ms. Hearing Officer, I submitted a document on July 14th, 2020 via email to be placed in the record. The document I submitted today supersedes that document, and I'll explain why later. The residents of Magnolias at Dawn subdivision are opposed to the setback of 30 feet from the south property line. A house built at a 30-foot setback will be inconsistent with all other homes in the subdivision. Other options appear available to include moving the house closer to the EPC setback line, moving the house west and north away from the south property line, requesting a setback variance from EPC, or change the footprint of the house. Additionally, in the initial filing dated January 21st, 2020, the applicant filed a site plan that indicated the house would fit on the property without any variances. We will agree, my wife and I, to a 40-foot setback as opposed to the 30. Secondly, we are opposed to the variance to allow a 1,200 square foot accessory structure. Throughout this variance process, this structure has been described as a garage. In the June 17th, 2020 revision, the site plan showed a 2,000 square foot structure with no height indicated. In the June 30th, 2020 revision, the size was reduced to 1,200 square feet with a height of 26 feet, 6 inches. After additional inquiries regarding the height, it was revealed in an email from Mr. Pressman dated 7/16/2020 that the garage will now have a loft and a small gym. This information was not included in the June 30th, 2020 revision. This garage is now a 2-story building and more than a simple garage, in my opinion. The information in Mr. Pressman's email was provided 2 days after my previous document dated July 14th, 2020. Based upon this, we are opposed to a 1,200 square foot structure. We're also opposed to the request to increase the fence height from 4 feet to 6 feet at the south property line. This would be inconsistent with the rest of the subdivision, as no other houses have a 6-foot fence in a front yard. Mr. Pressman made a point that it fits the neighborhood. It doesn't fit our neighborhood. There's no fence above 4 feet in anybody's front yard. And I also want to clarify, I don't know if I heard him right or not, but they want this fence to go at the property line, which would be the 20-foot line, all the way down the 600-foot property line on Sweet Magnolias Lane. Be totally out of character for the rest of the subdivision. I also own lot number 3. That lot has issues regarding building that are far more substantially difficult than the lot that they're asking a variance for. It has a 150-foot setback, it has a creek runs through the middle of it, So the majority of the houses in this subdivision have had to deal with some issues regarding creeks, wetlands, dry ponds from EPC. So this is not the only house, only lot that has to deal with those issues. Thank you.
Thank you so much. If you could please sign in. All right, anyone else that would like to speak in opposition, either in the room or virtually?
Is there a George Michael, or I'm sorry, Michael George virtually?
Mr. George, he just
All right,
spoke.
I'm just
so
making sure there's
I
not
think
a
that's it.
secondary sign up.
All right, perfect. All right, then with that, we will go back to county staff. Mr. Hisney, do you have anything else?
Yes, just a couple of comments with regards to this variance vis-a-vis deed restrictions. The county plays no part in deed restrictions. Those are private agreements between property owners. And the county plays no role in their enforcement. This variance is a variance to the requirements of the Land Development Code, which may or may not comport with particular deed restrictions. It was stated that this variance would somehow amend or affect the deed restrictions in this community. That is not correct. This variance is, again, to the Land Development Code and in no way amends any deed restrictions, and not just in this case, in any case. And then there was a question about the appeal process. I would direct attention to section 10.05.01 of the Land Development Code. It clearly outlines the time frame that parties have to appeal a decision, and also the requirements that as far as submitting your application and things like that in order to be able to file an appeal. Unless you have any questions.
I don't, thank you. Mr. Clark at the county attorney's office, if you just could quickly
here.
just touch on that appeal question and the date. And if
Yes, as the
that is
gentleman-
required to file an appeal.
Yes, the gentleman, the section that he's referring to is section 10.05.02 of the Land Development Code. It outlines the procedures for appealing decisions of the land use hearing officer to the Land Use Appeals Board. I recall that I believe it's a 30-day window from the time of the hearing officer filing a decision. There's a 30-day window to file a notice of appeal. The process is described in the code, and I'm always available to take any questions from citizens or applicants on issues like this. And I'm reachable at ClarkC, C-L-A-R-K-C, at hillsborocounty.org.
Thank you for that clarification. I appreciate it. All right, we'll go back to Mr. Pressman, who has 5 minutes for rebuttal.
Hearing officer staff, Todd Pressman again for the record. Hearing officer, the Coors bought a lot, the Wills bought a lot for the forever home. And they would like to be a part of the neighborhood. Now, the greatest respect for the neighbors who came down here today. I know Mr. Bennett for quite a long time. They're fine folks. We just disagree with them. I will tell you that I have approximately 30 emails back and forth between Mr. Bennett and the staff. I spoke with Mr. George on the phone. My first email to Richard, which I have here, is been a long time, hope you go well, wanted to touch base about the variance. Understand you have some concerns. P.S. I tried to call, but your phone did not seem to be working. Richard and I had quite a number of conversations, as we do with the neighbors. That's one reason why we made the variance as tight as we could make it. There have been changes through the process. There have been corrections to the process, but there's not been an email or phone call that I've received in the last 3 or 4 weeks. So as far as we're concerned, as far as staff is concerned, why we're here today is that everything had been settled out just fine. In regard to the comments made, the plan shows 1,200 square feet. We looked at that, we talked about it, it's 1,200 square feet. At our last house, we had a piece or two of gym equipment in it. And that's what Mr. Wills plans to do here. Its primary purpose is as a garage, and they're going to have a couple pieces of gym equipment. I don't think that's germane to the variance, and I don't think use is germane to the variance. That's a typical use that you find in homes throughout Florida or anywhere else. We also, after speaking with the neighbors, we also chose and put forward on the PowerPoint, as you saw, the type of fence that is proposed. We made that of record. So that was another response to neighbors' concerns about a large fence being put up at 6 foot high. I think that dramatically and significantly reduces concerns or impacts in that regard. Beyond that, in regard to comments about lot size configuration, I'll leave that to you. I think just looking at the aerial, it becomes very clear what the situation is, and I won't respond other than I'm sure you'll look closely at that.
I just have one quick question based on the comments. The gentleman testified that it appears that the house could be moved to the west and not need the setback variance. Can you talk to me about that analysis, why it's in its location?
Yes. Homes typically are located in the center of a lot. So they wanted to take advantage, not take advantage, but have a location or placement of the home like everyone else does, which is primarily in the center of a lot. So that you have a setback to one side, setback to the other, particularly in a 1 acre property. You're not going to push, you don't see homes push the one extreme end. You see them centered on the lot as the architect designed, and my conversation with the architect was that it would be, generally, as we discussed it, it would be better placement and better centralization as much as possible for the length of the lot. You want the placement of the structures to reflect the lot in some respect. It also keeps the home away from the property owner on the other side, of which I believe they're also adding some landscape in there as well. So it keeps the lot in a more open 1 acre rural type setting rather than shoving a structure to the immediate side.
All right, that was my only question. Does
Sure.
that complete your testimony?
Anything else to add? Oh, come on up, Mr. Wills, please. Give me just 1 second. Oh, yeah, please. Oh, yeah.
Give us your name and address, please.
Yes, my name's Corwin Wills, 1410 Emerald Hill Way, Valrico. We appreciate you guys having us here today. The trees that he showed in the pictures were donated to the Veterans Memorial Park. We felt the lot already had a lot of trees on it, so we didn't want to plant those trees there. So we donated them to the park to become compliant with the violation.
So the letter that Ms. Hull put into the record, that is in response to the violation you were issued?
That's correct.
That you're in compliance?
That's correct.
Thank you. All right, if you could please sign in with the clerk's office. Anything further, Mr. President?
Yeah, I should have said up front, my status with this case is as an agent, just for the record, in working with Wills.
All right.
Thank you.
Thank you with that. And so with that, we'll close variance 20-0494 and go to the next case.
The next case is item G3, variance 20-0601. The applicant is Ivan Perez. The request is a variance to the minimum lot size by utilities. Staff findings will be presented by Laura Marley.
Good morning, Laura Marley, Development Services. A minimum lot size of 1 acre of upland is required for the use of a septic system. The applicant is requesting a reduction of 0.02 acre to allow for the size of a 0.48 acre of upland lot to utilize the septic system. Public utility staff has confirmed that the connection to public wastewater service is not cost feasible. Thank you.
All right, thank you. Is the applicant here? You can come forward, please. You start by giving us your name and address. I appreciate it.
Good morning. My name is Ivan Perez, Ivan with a Y. I live in 3442 Dragon View Court, Valrico, Florida. I'm here today with my wife. Thank you all for having us here. On December 2017, we bought a piece of property. It's in the same road that we live right now. We live in a condominium, so we just had the dream of building our house. And we just saw the property. We didn't know the regulations for septic tank to be built in the property. That's something that you don't know as a regular citizen. So we started the process to get the drawings from the architect, and then we came to the county to get the permits for building our house. We were so surprised of the situation because we didn't know that almost we lost the investment that we did because of the considerations. But we started talking to the neighbors. I have a neighbor on the right. He built his home on 2007, and he had the same issue because we both have in a split property. So we were like 1 or 0.98 acres. So the previous owner, he split both lots in half. So we got 0.48 acres per lot. So I tried to start finding with the county what was the way to fix the situation, and they told me that I had to require a variance. Due to the cost of the variance, I was saying, oh my God, why we had to do this? So I started trying to find some information, the reasons why I had to go through the process. And I got an email from George Goodwin, which is a senior engineer specialist in Hillsborough County. And I don't know if I can just present it here.
Sure, absolutely.
This is in the record of this variance, but he just said that connecting to a sanitary sewer force main is not recommended for a single family home. And, you know, I was just, when I got this information, I said, okay, someone that knows what he's saying, he's just telling me that I cannot connect to the force main, which is, I think is very costly for one home. So that said, we started the process. We've been pushed for the situations with the pandemic. So we're here today trying to get all the requirements needed to get the variance of 0.02 lot, 0.02 acres to get a septic tank in the property. I want to show just one more document. This is my neighbors. That's my neighbors. Richard Campbell, the final decision, which was approved because he was able to build his house. As I said, we were in the same original parcel. We got split it, and you know, things were not maybe done right, but we're here and we're just trying to get this resolved to get going with the house. So we need your help, and that's why we're here. Thank you.
Thank you so much for your testimony. If you could please sign in with the clerk's office. All right. Is there anyone that would like to speak in support? Anyone in favor of this application? All right. Seeing no one, anyone in opposition? No one. Mr. Hisney, anything else?
No, ma'am.
All right. Sir, do you have any other comments before we close? That's it. All right. Thank you so much for your testimony. We'll close variance 20-0601. Go to the next case.
All right, next case is item G4, variance 20-0614. The applicant is Charles Sochi. The request is a variance to lot development standards. Staff findings will be presented by Laura Marley.
Good morning. Good morning, Laura Marley, Development Services. The applicant is requesting a variance to the required front yard setback to accommodate an existing single-family dwelling. A minimum yard setback of 25 feet is required. The applicant requests a 5-foot reduction to the required front yard to allow a 20-foot setback. Thank you.
Thank you so much. Is the applicant. Good morning.
Good morning. My name is Charles Sochi, 1406 South Parsons Avenue, Suite A, Seffner, Florida, 33584. I'm here to speak about this variance 20-0614. It's pretty simple. It was a human error that created this. I have. Okay, this is the tie-in survey showing the constructed block walls of the home. We're 20.1 feet currently, which we were supposed to be 25 feet. So we were 4.9 feet away from correct placement. What happened was I hired a surveyor that had a CAD file that he staked the building out from, which had an error in it, and no one caught it. These are pictures of where we started. This is when we started the project. I built every house on the street. We started at the end of the street. Had we started over here and worked this way, we would have caught the error. Instead, we started down here, and we wound up, as you can see, next to a finished house. This is the condition. It's barely noticeable, even 15 feet away. You can imagine when it was 300 feet away, but we didn't notice the plane of the house being out. The site conditions are, this is a dead-end street, so we don't have any issues with through traffic or being on a corner. This is the house with the variance sign in front of it. When I built all the other houses, I properly notified every buyer for every lot the conditions that they were going to be presented with the house not being conforming to the lot development code. No one had an issue with it. They still bought the houses. So I was also able to go back and find another variance that was approved in 2006 for my lot at the other end of the street, which is a corner lot, where they successfully reduced that 25-foot setback down to 14 feet. So this is not an unheard request. It's not crazy. It's not out of line. It's not going to create a hardship for any of the other owners on the street. This is a non-deed restricted lot. It is a non-subdivision lot. It's on a private maintained road. So really doesn't affect anyone except this lot owner who's been put at a financial hardship by not being able to have his house completed and move into it. The only other possible very costly resolution would be to tear this down and start over, which will impact the livelihood of the surveyor, myself, and the draftsman. So we would like your consideration to allow this variance based on the data that I've provided.
So after the initial permit was issued, the slab was poured, and then the error isn't found until the tie-in?
The tie-in survey is how the inspector noticed that we were not in plane with the other house.
Okay, and the house next door, is that occupied?
Yes, we sold every house on the street.
All right.
And I disclosed it to every single person before they bought.
And the most affected property owner next door, have you talked to them about this?
Yes, they just want to see the house finished.
Okay.
So they just want me to finish the house and clean up the mess and move on.
Understood. All right, thank you for your testimony. If you could please sign in.
Thank you.
All right, is there anyone that would like to speak in support? Anyone in favor? Seeing no one, anyone in opposition? No one? Mr. Hisney, anything else?
No, ma'am.
All right, then with that, we'll close variance 20-0614 and go to the next case.
Our next application is item G5, variance 20-0837. The applicant is Josh Horrocks. It's a request for a variance to lot development standards. Staff findings will be presented by Kevy DeFrank.
Good morning, everyone. Kevy DeFrank with Development Services. Can you hear me?
We can go ahead.
So for this case, the applicant is requesting a lot width variance to accommodate a 2-lot subdivision of property zone RSC 6. And per the Land Development Code, the required minimum lot width in the RSC 6 zoning district is 70 feet. The applicant requests a 10-foot reduction to the required lot width to allow a minimum lot width of 60 feet for each of the lots in the proposed subdivision. And I would like to highlight one of the findings, which is each of the proposed lots will have a depth of 156 feet approximately, resulting in a lot area of 9,360 square feet. And a minimum lot size of 7,000 square feet is required in the identified zoning district. Thank you, and I'm available for questions.
I don't have any questions right now, but thank you so much. Is the applicant here? Is the applicant here for variance 20-0837? All right, Mr. Hisney, any word on the status of the applicant? You don't know?
Not that I'm aware of, no, ma'am.
All right, well, let's do this then. Let's hold this case and bring it up at the end. Oh, you all are here to speak to this case? Mr. Clark, County Attorney, can we take their testimony?
I'm here. Can you repeat the question as far as
Yes,
someone's
sir.
there
The
to
issue
testify
is
virtually or in
the
person?
county did their presentation and now the applicant is not here for this case. It's variance 20-0837. No word on where the applicant is, but there are people here that would like to speak and they'd like to speak because they've come down here. Go ahead and take their testimony.
Does staff have any communication with the applicant? Are they expected? I know when this has happened before, I think we've deferred the case to the end of the agenda just to, in case the applicant wishes to show
Staff
up.
has no knowledge of the status of the applicant.
Madam Master, yeah, we're placing a call now to the applicant. We didn't have any advance knowledge of how they were going to attend, but we're attempting to call him now.
So, Mr. Clark, the concern is that there are folks here that would like to speak to the case.
Ms. Finch, I might suggest initially, just as we have in the past, deferring the case to later in the agenda. If the applicant ultimately does not show, at that point, a decision is going to have to be made. I'm not sure if this is the first time it's come up on if this is the first time this case has been on the agenda or not, but whether or not to continue the case. I think since the case was properly noticed, if in the end the applicant does not appear, and there are people who have shown up to speak, I think it would be proper to go ahead and let them enter their testimony in the record and then potentially defer the case to a future agenda. But at this point, I think, I believe in past practice, if when this sort of thing has happened, we've deferred the case to later in the agenda, at least to start.
But in summary, if we can't find the applicant, it would be appropriate to take their testimony today.
I think the only concern I have about that is that the applicant's not present to hear what these parties are stating, but there are, of course, mechanisms for the applicant to, obviously this is being broadcast, so the applicant can, of course, revisit the transcripts or the video to watch what was said. I have a little concern about testimony being entered into the record where the property owner is not actually present to hear it and react to it. But in this instance, at least for the time being, I think it would be a good decision to try to reach the applicant and see where we are later in the agenda.
Thank you so much. All right, so I apologize, but this is beyond our control. What we're doing is trying to reach the applicant right now to find out what the status is. So I'm going to have to move forward. We're going to continue this to the end. If we get an update before then, I'll obviously let you know.
We attempted to call them and it went to sound like a fax or number or something, but we couldn't get through.
All right.
Right now.
Well, let's do this. Or do we have any other way to contact them? Okay.
Try an
So
email.
let's continue that case for the moment. We'll hold that case and go to the next one while we try to
Also,
reach.
Kevy? Well,
Yes.
No, sorry, Kevy has the next case as well, but when we get done with that, maybe he can try to outreach as well.
Absolutely. All right.
right.
So let's hold that and go to the next case.
All right.
He just emailed.
Item G6, variance application 20-1030. The applicant is Troy and Barbara Emick. The request is a variance to lot development standards. Staff findings will be presented by Kevy DeFrank.
Kevin DeFrank with Development Services. So for this case, the applicant is requesting a setback variance and lot coverage variance for a proposed single-family home that will be constructed on a property zone RSC 6. Now, per the Land Development Code, the required minimum rear yard setback in the RSC 6 district is 25 feet. And the applicant requests a 15-foot reduction to the required rear yard setback to allow a rear setback of 10 feet. Now, per the Land Development Code, the maximum permitted building coverage in the RSC 6 zoning district is 40%, and the applicant requests a 14% increase to the permitted lot coverage to allow a lot coverage of 54%. Thank you. I'm available for questions.
No questions at this time. Thank you. You're the applicant? Good
Yeah.
morning.
Yes.
Give us your name and address, please.
My name is Troy. The folio, it doesn't actually have a address. The folio number 012-805-00000. We're basically asking for permission to build the house within 10 feet of the backyard. It's not an uncommon thing that's in the neighborhood. The property just to the south of me is actually only 12 feet from the fence. And then the property just to the north, next door, they have a 5-foot wall that's literally about 3 feet away from the fence. So it's not something that's very uncommon for this neighborhood. We lived in this community since 2005, so 15 years. We've had a couple of kids. We're just outgrowing our house. My neighbor actually sold me the lot so we can build our dream home. And we just need these couple things so we can proceed with that.
And I saw in your application, there's an oak tree in the front yard.
There is a beautiful oak tree. It's a massive tree. So I would like to keep that as well. By sliding the house back, it gives us the clearance to be able to build the house and not have to remove that tree.
Okay. All right. I think that was my only question.
Yeah.
So did you have anything else you wanted to say?
We have letters from our
Give us
neighbors.
your name and address, please.
Oh, I'm sorry. It's Barbara Kathy Amick, and the foil is
012-805-00000.
Thank you.
And since we couldn't have most of our neighbors come and support us, they wrote letters. I didn't know we had to have 5 copies of.
You don't.
each.
You only
Okay.
have to have one, and you can submit it to the clerk's office, to the clerk, and I'll see it.
Okay,
Yeah.
great. Thank you.
All right. Does that complete your presentation?
It does.
Thank you so much. If you could please sign in and then submit whatever documents you want to submit.
Thank you.
Perfect. Yeah. Anyone here that would like to speak in favor? Anyone in support? Seeing no one. Anyone in opposition? All right. No one? Mr. Hisney, anything else on this case?
No, ma'am.
All right. Then with that, we'll close variance 20-1030. Do we have any update on the previous case?
Yes, we do. We've
Okay.
gotten in touch with the applicant. He wasn't aware that he needed to appear. However, we now have communication staff in touch with him on how to virtually access this meeting. So I would suggest that we go to G7.
Do one more?
And
Okay,
then hopefully
perfect.
by
All right.
then he'll be set up.
Then let's call the next case.
All right, item G7, variance application 20-1065. The applicant is Mark Stryker and Stacy Paree. They are requesting variances to accessory structure requirements, fence requirements, and also for a wetland setback encroachment. Staff findings will be presented by Tanya Chapella. Tanya?
Ms. Trapella, are you there? Ms. Trapella, are you there?
Okay, can you do the?
Sure,
summary for us?
I'll present staff findings.
Thank you.
I'm sorry for the
That's okay.
communications problem. Okay, the applicant is requesting variances to accommodate a proposed detached shed and fence on a corner lot zoned ASC1. The applicant is also requesting a variance from the required wetland conservation area setback for an existing retaining wall and existing proposed fence. With regards to the shed, accessory structures are permitted in front yards at twice the depth of the required front yard of 50 feet, whichever is less. The required minimum front yard setback for this property is 50 feet. The applicant requests a 29-foot reduction to the required setback to allow a front setback of 21 feet from the west property line along North Mobley Road. Additionally, accessory structures greater than 15 feet in height must meet principal building setback. As stated previously, the required front yard setback in this property is 50 feet. The proposed garage, according to the applicant, will have a height of 25 feet. They are therefore asking a variance to the required minimum front yard setback of 29 feet to allow a setback of 21 feet from the west property line. With regards to the fence, fences in agricultural districts such as ASC1 are regulated in the same manner as fences in residential districts, except in certain circumstances that do not apply to this case. Fences over 4 feet in height are not allowed in required front yards, except in certain circumstances that do not apply to this case. The applicant requests a 2-foot increase in the permitted fence height to allow a 6-foot high fence within the required front yard along North Mobley Road. As shown on the site plan, the fence will be set back 20 feet from the west property line. We also then have a wetland setback variance. Carla Shelton, are you logged in? Application staff, is Carla Shelton logged in?
I do not believe so.
Okay, I'll go ahead and read that one then. Land Development Code states that no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests approval for after-the-fact construction of an existing retaining wall and placement of a new fence in the same location as the existing chain link fence within the 30-foot wetland conservation area setback. The applicant requests a 30-foot reduction of the setback to allow for a setback of 0 feet. And that's it.
All right, I just had one quick question, just to clarify in the staff findings on page 2 regarding the non-conforming lot, it notes that the lot is less than an acre, 0.87, but on the agenda, it says it's 1.05.
Yeah, if you go into GIS, in the property appraiser, it says it's slightly over an acre. The survey submitted by the applicant says it's slightly under an acre. We deferred to the survey submitted by the applicant, as we believe that, is more definitive than what's placed on, shows up on GIS.
Yeah.
So that's the discrepancy there.
Okay, fair enough.
Also, I'd like to point out in the lead of this is not a corner lot. So
right.
Doesn't affect any of the variances, but it's not a corner lot.
Right, okay. All right, is the applicant here? Good morning.
Good morning, Isabel Albert with Half Associates, assisting the applicant in this rezoning, or actually in this variant. I have not been sworn in.
Oh, okay. Is there anyone in the room that plans to speak on this case or any other case that has not been sworn in? If so, please stand and raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you so much. Please continue.
Good morning. Thank you for having me today this morning. So what we have here, this is a site that is currently, has a residence on it. It's an old residence. It's been there for a long time. It's a lot of record of prior to 1989. And so the applicant purchased the property and wants to improve it with a new home and a new garage and just spruce it up a little bit. So basically what they have here is they have this shed. They're proposing this shed there. There's a current shed at that location. So they're just want to replace it at the same location as currently it is right now.
Same footprint?
No, bigger footprint.
Bigger,
but
okay.
Same like setbacks.
Okay.
In fact, the existing shed is closer to the property line to the south. So this will bring it to conformance to the side yard setback.
I see.
And they're proposing a 20-foot setback from the front where 50 feet is required. So that's in regards to the shed. The fence here, there's an existing chain link fence here, and it's 5 feet high, and they want it to go to 6 feet tall with the iron fence. And the goal here is, so what we have here, this is an existing fence. It's set back 20 feet from the property line over here. And there's 6 to 8 feet shrubs over here.
And it's 5 feet tall existing, you said?
The existing 5 feet tall chain link fence.
Okay.
And so what they want to do is to remove the shrubs and replace the fence with wrought iron fence, which is similar to the property to the north of them, which has a 6 foot with column fence along, and they're just adjoining it to there. So this is over here. You'll see this is where the shrubs are.
If you could just bring that photo down just a little bit. There you go, perfect. Okay.
So here's the shrubs that I was talking about for the neighbors. And this is the fence here. And as they go along, it will match up with the proposed new fence, the 6 foot iron fence.
I see.
And the idea there is to keep it open is when, the setback for the fence, 6 foot fence, was to keep the openness of the site and visibility. And so with the wrought iron fence, we're still going to maintain that visual. And lastly, this came about after filing for the application, is that there's some wetlands in the back. And as I said, this site is already improved with the residents, and there's a retaining wall. And I think according to historical research, this retaining wall has been there since like 50s. It's been there for a long time. The fence, the chain link fence is falling apart, but it's been in that location for a very long time. And what we want to do is we're not touching the retaining walls. It's been, I guess, patched up, but it's been fine as just to replace the fence, exactly at the same location. So that's how we would be encroaching into the wetlands, but it's an existing encroachment. And so we're not making it worse.
Okay.
These are improvements or variances that are not going to be really affecting any neighborhoods. They're trying to enjoy the property like all their neighbors around there. It's keeping with the aesthetics of the neighborhood. And that's all I have, unless you have any questions.
I don't. You answered my question, so thank you. I appreciate it. All right. Is there anyone here that would like to speak in support? Anyone in support of this application? No. Oh, if you could sign in, please. All right. Seeing no one, anyone in opposition? No one. Mr. Hisney, anything else on this case?
Yeah, well, we got in contact with Carla Shelton.
Okay.
In case you have any questions for her regarding the conservation setback.
No, Miss Albert explained that the fence is to replace the existing wall, as I understand it.
In that case, then, no further comments from staff.
All right, perfect. Then with that, we'll close variance 20-1065 and go back. Do we have the applicant yet?
Well, we got a hold of the applicant on G5. I guess he didn't have a means of having visual participation, just audio.
Okay.
And so he stated he wants the case to go forward without him. That's what he stated. He's waiving his.
All right, let's just verify, Mr. Clark. His office.
Sorry, go ahead.
Yes, the staff has contacted the applicant and he has no means of participating visually. So he would like the case to go forward without his testimony.
Okay, if the application's complete and able to proceed without testimony, and he's comfortable that there may be citizen opposition to his application that he won't be able to hear. If he's stated to staff he wants the application to proceed, then I believe it can proceed.
Okay, then let's go back and open G5, Mr. Hisney.
Go back to G5.
Oh, Tom, your microphone's not on.
I'm sorry. So back to item G5. I'm sorry, I can't remember. Did Mr. DeFrank present the staff findings?
Yes.
Okay. All right. So.
All right. So back to the process. Variance 20-0837. Mr. DeFrank of the county staff previously testified regarding the county findings. The applicant is not in the room and is unable to participate virtually, meaning that he cannot have a visual from his home, wherever he's participating from and is elected to proceed without his testimony or participation. So we're going to move forward. So at that point in the process, we'll call for anyone that would like to speak in favor. Anyone in favor of this case? Seeing no one. Anyone in opposition? All right, how many people want to speak? 3 total? Okay, if you can go ahead and come forward. 15 minutes total, so that will give you 5 minutes each. If you, I'm sorry? Oh, one person virtual. All right, so if you'll divide the time, the 15 minutes between 4 people. And if you could start by giving us your name and address. Good morning.
Hi, thank you for.
You could bring this to you, the microphone that's in front of you. Yeah, just bring it down a little bit. Perfect.
How's this?
Better, thank you.
I'm Peggy Sherman. I live at 11711 North Rome Avenue, which is across the street and down 2 houses from the property in question. First of all, this property being divided into 2 60-foot lots would not fit our neighborhood. In fact, many of the lots are larger than 120 feet already. Our neighborhood has put up with 5 years of absolute untold grief regarding this house that has been in various stages of falling down with an unsafe swimming pool for 5 years. So this has been going on for a long time, and we've really endured a lot. In fact, today they're starting to tear down the house. So we're happy to have that underway. And now they want to put 2 big houses on 2 small lots. And that type of thing would only help the builder. The people that would eventually live there would not receive any benefit from having a smaller lot. The future owners would probably have preferred to be in a larger lot. Our neighbors will live with this forever. We really do hope that you don't approve this, and we really need your help because this is not going to change. The builder will be there for a short time. He'll be gone, but we'll all still be living there. Thank you.
Thank you. If you could please sign in with the clerk's office. Next, please. Good morning.
Good morning. My name is Muriel Hobby, and I live at 11714 North Rome Avenue, right next door to the property in question. They want to take a 120-foot lot and divide it into 2, which means that each lot is going to be 10 feet under code restrictions. So my husband and I object to this variance request for the following 2 reasons. The existing lots from the cross street of Echoes south on North Rome are all full-size lots with 1 house per lot. Putting 2 houses on a substandard lot size, each being smaller than code, would not fit the existing community. The second reason why we object to this is the owner, Rahim, incurred code violation fines, and his financial commitment to this property is substantial. To recoup his investment, he would have to build 2 houses, sell them to earn enough money to recoup, in which case our property value would go down. I thank you for your consideration. There's no reason why, and like Peggy just said, they are taking down the present house. They started last Friday. They're continuing it today. I think they're in code violation, but nobody from code has called me. This is a house that was built with asbestos. It's supposed to be a wet demo. A wet demo is supposed to have a water truck with a fire hose. They are using a garden hose for a wet demo. So, and we are right next door to them. So, there have been many issues with this house, and I appreciate your time and consideration. Thank you.
Thank you for coming down. If you could please sign in. Next, please. Good morning.
Hello, my name is Paul Lynn. I live at 11507 North Rome Avenue. I've been there 53 years, and I tell you, there's never been a house in the neighborhood that's caused as much trouble as this one has. I mean, we have put up with this blight, and I mean, it is a blight for more than 5 years. But anyway, they've pretty much summarized all this. We did a survey at one time when they were trying to cut up a lot of small lots in our neighborhood, and it really has no benefit for the Forest Hills community. Even though we are about 150 yards inside of the city, the house is about 100 yards outside of the city limits, it still is going to affect us. We have gone to the point of where we couldn't even get out of our driveway because of the traffic. We have a major school, grammar school. We have a 7-Eleven. We have a small strip shopping center and a large church. And we've seen traffic backed up a whole block there. Couldn't even get out of our driveway to go to work. So this isn't something we need in our neighborhood. We want to be compliant with all the rest of our property. Thank you very much.
Thank you, sir. If you could please sign in. All right, well, we have one person to participate virtually, Mr. Olson.
Mr. Olson, are you there?
I'm able to, I'm having, hello?
Mr. Olson, we hear you,
Yeah, I'm
but
having trouble.
we need you to enable
Yeah, I'm
your
trying
video
to share
camera.
my video. Yeah, I'm trying to share it, but I just called in on my phone because I'm able to see you, but I'm unable to hear on my computer. So I'm doing the best I can to call in. Watching the screen right now, and it's showing that it's trying to share my video, but it's unable to at this time.
So this is Cameron Clark. Can I interject, Madam Hearing Officer?
Please, Mr. Clark.
Yeah, in order to be able to participate virtually, as the notice provided, someone providing testimony has to be both visible and audible to the hearing officer. So there's any number of devices, laptops, tablets, even a smartphone, that you can use the link that was provided for this meeting to link to WebEx and be both visible and audible to the hearing officer. So that's the first part. And the second part is the only way that anyone can share a screen or something along those lines in order to provide visual documentation and support over a position to an application, those materials would have to have been submitted to staff at least 2 days before the hearing. We don't have the ability to capture something like even a PowerPoint or something along those lines in the middle of a hearing. Photographs or things of those nature, anything that's being shown has to be submitted at the hearing, or if you're participating virtually, it has to be submitted 2 days before the hearing. And all that was provided for in the notice for this hearing today.
Right, I understand. Like I say, I've done everything I could. I have the link, I have the paper in front of me about participating virtually, and I've tried and I have the link to my email in order to participate, but unfortunately I'm having technical difficulties. That's why I'm calling in on my phone. I just saw my neighbors speak, Mr. Lynn, Ms. Sherman, and Ms. Hobby. I just saw them speak about I'm watching it happen, but I'm unable to share it, my screen virtually. So I'm doing everything I can based on the instructions that were provided to me.
Okay,
I'm not sure anything to submit. I just oppose the project as I want to voice my opinion. Opposing the project.
I understand. So if you don't have if you have no additional materials to submit, then that part's not a problem. I don't know if maybe there's the opportunity for you to talk with the technical staff, because I know it has happened.
There's my video. That's me right there with on the phone.
He is on now.
So
we are seeing your camera, sir.
Okay, so even if the two things aren't linked, if it's possible for us to both see and hear you, then I think you're good to go.
Okay. I do see you, Mr. Olson.
Okay, thank you. Yes, I'm opposed to the variance, the variance as submitted to build 2 homes on the property. Like my neighbors had spoke, I live at 11715 North Rome Avenue, across the street from the project. I'm opposed to it, not opposed to them redeveloping the lot into one house, but the 2 homes don't fit with the character of the neighborhood. It increases the density, increases the pressure on county services. So I'm opposed to it in those regards. That and then also that it'll end up causing a decline in our property values, and then the developers don't live in the neighborhood. I've spent significant amount of money recently remodeling my existing home. Spent over $100,000 doing that. My neighbors directly north and south have also recently done remodeling their home. The hobbies across the street and next door to the project have spent significant funds remodeling their existing homes to keep in character with the neighborhood. And I just feel that if this variance is approved, then it just creates that vacuum for other developers and others to come in and tear down homes and build 2 homes on lots and further subdivide lots. And like I say, increasing the population density, increasing pressure on services, and also decreasing my home value. And I'm opposed to it on all those regards. And that's I just wanted to speak my piece, and that's what I had to say.
Great. Thank you, Mr. Olson. I appreciate it. I'm glad we got it worked out. Anyone else?
Thank you.
Just to make sure I have last call that would like to testify in opposition. Anybody else? All right, Mr. Hisney, anything else on this case?
No, ma'am.
All right, and we don't have the applicant to go back to for any questions. So with that, we'll close variance 20-0837 and go to the special use section of our agenda.
Okay, so we have 2 special uses today. The first one is item H1. This is special use 20-0179. The applicant is Bullfrog Creek Mitigation Bank LLC. The request is a special use permit for a land excavation. Staff report and recommendation will be presented by Colleen Marshall following the applicant's presentation.
All right, good morning.
Good morning, how are you?
Good, thank you.
Should I bend this forward or up? No, just leave it. My name is Jesus Murley. I'm with 5M Civil LLC in Tampa. I'm representing the Bullfrog Creek Mitigation Bank. Thank you. I didn't know if you heard me. There you go.
Perfect.
Okay, I'm the engineer for the project. The environmental scientist is here as well. As I said, this is a mitigation bank. The purpose of the mitigation bank is to develop wetlands and sell wetland credits for development, including the FDOT as a prime client. We will be taking disturbed lands that have been receiving or has been a recipient of agricultural runoff for quite some time and has degraded some adjacent wetlands. And what we're planning to do is to create wetlands in upland pasture areas and remove sediment from agricultural runoff in existing wetland areas. The next step would be to then plant wetlands and create them. I don't have any other additional evidence to add with regards to trucking or material that we are proposing. Everything else is as specified in the special use plan. But that was just a brief overview to get you all familiar with the project.
All right, thank you so much. If you could please sign in with the clerk's office. All right, county staff.
Ms. Marshall, we can't hear you. No, ma'am, we can't hear you. No, you might want to try disconnecting that headset. We can hear you, but it's very low. We cannot hear you.
Can you hear me over the webcam?
Yes, now we can hear you. Just try to speak slowly because it is a little room tone.
Okay. The request today is for a special use land excavation permit to allow the removal of 198,600 cubic yards of material to restore existing wetlands on the site and create additional wetlands for the Bullfrog Creek mitigation bank. The proposed excavation area is approximately 33 acres in size and located on a 173-acre parcel zoned land development. 25-foot distance separation is required from any non-residential property line, including agricultural uses. The applicant's requesting a waiver to this requirement along the eastern portion of the site to allow a 0-foot distance separation. Staff has no objection to the proposed waiver, given the justifications provided in the staff report. A 500-foot distance separation is required from any residentially developed or residentially zoned property line. Residentially developed property exists to the west of the subject site. The applicant's requesting a waiver to reduce the required distance separation to residentially developed property to 321 feet. Staff has no objection to the proposed waiver. A 30-foot distance separation is required from any wetland conservation area. The applicant's requesting a waiver to this requirement to allow a 0-foot distance separation. For the applicant, the purpose of the proposed land excavation is to construct wetlands. Sediment will be removed from the existing wetlands. An additional wetland area will be created to expand the wetlands as part of the Bullfrog Creek mitigation bank. Development Services staff has no objection to the proposed waiver. Lastly, a waiver is requested to allow for access through an easement to a local road, Westlake Drive. The access driveway for haul trucks will be located along the eastern boundary of the site and proceed to an easement across the site and west to Westlake Drive. The haul trucks will proceed north on Westlake Drive to Bill Tucker Road and west on Bill Tucker Road to US 301, then to and from delivery destinations in accordance with the truck route plan. Given the relatively limited duration and scope of the proposed excavation, staff has no objection to the proposed waiver. Staff finds the proposed land excavation approvable, subject to recommendations of approval. I'd be happy to answer any questions.
But thank you so much. All right, we'll go to the Planning Commission.
Good morning. Yanika Mills, Planning Commission staff. The subject property is located within the Waimama Village Residential Plan 2 future land use classification. It's also located within the rural area and the Waimama and South Shore area wide community planning areas. The proposed land excavation meets the intent of policy 10.9, objective 11, and policies 11.1, 11.2, and 11.5 of the conservation and aquifer recharge elements. Additionally, the request also meets the intent of policy 1.4 of the future land use element regarding compatibility. Based on those considerations, Planning Commission staff finds the proposed special use consistent with the Future of Hillsborough Comprehensive Plan. Thank you.
So much. I appreciate it. All right, we'll call for anyone that would like to speak in support. Anyone in favor? Seeing no one. Anyone in opposition to this request? No one. Mr. Hisney, anything else?
No, ma'am.
All right, sir, anything else before we close?
Yeah, I just wanted to add one more
You can just
thing.
give us your name for the record.
Oh, I thought I did that already. I'm sorry.
Every time you
Jesus-
come back up, just
Okay.
because we're recording it.
Jesus Murley with 5M Civil.
Thank you.
And the only thing I wanted to add, I wasn't sure if it was in the report, and Colleen might have mentioned it, but those setbacks, the encroachment to those setbacks from the adjacent farming community or property is to provide stormwater treatment areas. So that's the reason for the additional or the setback, the encroachment into the 500-foot setback.
All right, thank you for that clarification. So with that, we'll close special use 20-0179 and go to the last case.
Yes, our last case today is item H2, special use application 20-0233. The applicant is Patricia Ortiz. The request is for a 4 COP alcoholic beverage permit, which requires separation waivers. Staff report and recommendation will be presented by Israel Monsanto following the applicant's presentation.
Good morning.
Good morning, Ms. Finch. For the record, Patricia Ortiz. My address is 2810 North Central Avenue, Tampa, 33602. I'm here today on behalf of Innovative Design Leaders, and we are seeking an alcoholic beverage special use with waivers to the distance of separation between residentially zoned property and community uses. The property is located in the Riverview Community Plan and will be developed with a high and dry style marina with 144 boat berths. This project was approved through Plan Development 18-1366 and was recently modified through PRS, but essentially the design has remained the same. Alcohol sales has always been a critical component of our development, and we're here before you today seeking this special use, which, if approved, will allow us the opportunity to apply for a 4 COP alcohol beverage license. I feel that the PD conditions of approval, the topography of the land, and the site planning really mitigate for the impacts of this use on adjacent uses. More specifically, through the plan development conditions of approval, our patronage was limited to only those storing boats on site and their guests. The hours of operation were limited to between 12 noon and 10 p.m., and amplified music is prohibited. Through the topographical features of the site, we really sort of mitigate the impacts of sound and travel between this site and the adjacent residentially and commercial community uses. Along the eastern boundary adjacent to US Highway 301, there's a significant slope of land which will really work to prevent the people from, or anyone from entering or exiting this area of alcohol enjoyment and leaving the site via 301. Also, the property is really unique in shape. The southwest corner of the property is bisected from the larger piece of land. So this little area over here kind of functions almost like an island, and it creates a very unique buffer between the area of alcohol consumption and the adjacent or most affected residence, which is 117 feet from the area of alcohol enjoyment.
What is that area used for?
Right now, it's not going to be used for anything. It has like a native wetland in that area, and it's bisected by a stream. So it really does sort of benefit the adjacent neighbor who for a long time thought that that was their own property. It's not. It is property associated with the marina and will remain in that pristine state.
Okay.
Okay. This diagram will help you understand where we're located, and perhaps I should have put this up first. But the area in red is the marina property. This is a secured access marina. People will enter the site from Moody Road. The area of alcohol consumption is here in blue, and you can see the nearest home is 117 feet away, but it is on the opposite side of that stream. The Riverview United Methodist Church is located over here at the southwest corner of the intersection of Riverview Drive and US Highway 301. So if a person were to go from point to point, say they wanted to leave this area of alcohol consumption and get to the church, if they were doing that on foot, they would, a reasonable person anyway, would have to go up here to the intersection at Riverview Drive, cross the 6-lane highway, and then they would be at the site. That's a distance of more than 1,000 feet. The situation would be much longer if you were traveling by car because you're restricted to a right out. So you'd have to travel all the way down to Riverview Balm at the signalized intersection, make a U-turn, and travel back. And the situation is the same if you were, you're really restricted from entering the adjacent neighborhood because there's a 50-foot wide unimproved right-of-way called Copeland Road, which is between the subject property and that neighborhood, access is prevented because Moody Road terminates at that point. So it's, if you wanted to, if you were in your car, you'd have to do the same thing. You'd have to go down to Riverview Balm Road, make a U-turn, come back to Riverview Drive to enter this neighborhood. It's highly unlikely that anyone would do that on foot. Again, we have the stormwater pond. We also have that area of land which separates the two properties. And through site design, we really feel that we have located this area of alcohol enjoyment in the appropriate place. It is most distant from both the residential zoning and from the community use, although it doesn't meet a strict interpretation or strict compliance with the code. We feel it meets the spirit of the regulation. It is sort of boxed in here between the highway, the river, the boat ramp, and the building. So we feel like these characteristics of the site design and the topography of the land will really mitigate the impacts of this use as far as sound and travel on those adjacent uses. So with that, I will answer questions you may have.
The only question I had was, in the staff report, the narrative talks about the 11C license, the prior,
Yeah.
and I just wanted to clarify on the record. So that recent personal appearance application, did that delete the 11C reference?
Yes, it did. And the reason for that is because the 11C license, although it is a license that's offered by the state, the information needed by both the county and the state to demonstrate compliance with your charter club is just very unclear. It's very difficult to determine what exactly is required. So we felt, and staff agreed, that moving forward with the 404 COP license and keeping that restriction on patronage would work to the same effect and be more easily regulated.
I see. Yeah, that was my only question.
Great.
Thank you so much.
Okay.
All right, we'll go to Mr. Monsanto.
Good morning. Can you hear me?
Yes, we can. Go ahead.
Israel Monsanto Development Services. This request today is for a distance separation waivers in accordance with the Land Development Code Section 61111 for a 4COP alcoholic beverage permit for the sale and consumption of beer, wine, and liquor on and off the permitted premises. According to the applicant, the proposed wet zone area will consist of 600 square feet of interior space and an outdoor area of 3,746 square feet. The alcoholic beverage is located within PD 181366, most recently modified by PRS 200529. This PD is approved for a marina with enclosed boat storage for a maximum of 144 boat slips and a drinking establishment restricted to patrons and their guests leasing a storage space. The total area for the drinking establishment, again, will have two components, an indoor and an outdoor. The site is located at 10531 Moody Road in Riverview. For the submitted survey, the applicant is requesting two distance separation waivers. The first one is for the distance from the proposed structure to certain community uses, which shall be 500 feet. There is one community use, which is the Riverview United Methodist Church, located 299 feet from the proposed wet zoning. And the second waiver is for the distance from the proposed structure to residentially zoned property, which shall be 250 feet. Residentially zoned property is located 117 feet west from the proposed wet zoning. The applicant has submitted the following justifications for each of the two waivers, and we as staff has evaluated the separation waiver justifications in accordance with 61111E3 and finds those to be reasonable based on the following factors. The PD today allows a drinking establishment up to 4,693 square feet in area, both indoor and outdoors. Conditions of approval require patrons of the drinking establishments to be active customers and their guests, leasing both storage space only, and it will not be open to the general public. Hours of operation are restricted and amplified music is prohibited. For the PD plan, the drinking establishment will be oriented south and eastwards towards the Alafaya River and US Highway 301 and away from residential uses to the west. Moody Road does not connect to the residential neighborhood to the west. where the two closest residentially zoned properties are located. The residences are separated by either 50 feet of unimproved right-of-way or by extensive vegetation, wetlands, and a stream. With no direct pedestrian or vehicular path, the normal route of travel to these residences will be or will exceed the required separation. Topography of the site as well will prevent direct access to the drinking establishment from US Highway 301. The area of the proposed wet zoning is below street level, and access to the site is restricted again to Moody Road. The only logical route to the subject wet zone area from the church would require crossing Highway 301 at the Riverview Drive intersection, walking to the entrance of the site on Moody Road before accessing the wet zone area. This route overall uses more than 1,000 feet of distance. Staff finds the proposed wet zoning distance separation requirements, staff finds the proposed wet zoning does not pose significant impacts on surrounding land uses, and the necessity for the specified distance separation requirements is negated by the circumstances identified in my staff report. Therefore, staff finds the request to be approvable, and I am available to have any questions.
I don't have any, but thank you so much for your testimony. Is there anyone in here that would like to speak in support? Anyone in favor? Seeing no one, anyone in opposition to this request? All right, Mr. Hisney, anything else?
No, ma'am.
All right, Ms. Ortiz, anything before we close? No, okay. All right, thank you. Then with that, we'll close special use 20-0233 and adjourn the hearing. Thank you all for your time and testimony.